Sure. Thank you. Thank you for your time. So the interesting thing, I think, that is happening in most of the emerging markets in the vertical sphere is that these markets do not per se, or at least some of them, do not per se have the same goal of single market integration that you would see in the EU, which sometimes means that in terms of vertical restrictions, these competition authorities of these countries can be a bit more lenient because it's not an attack on the fundamental tenets of a supranational body when you come up with certain vertical restrictions. So there is a bit more of a rule of reason, which is already available in the vertical sphere anyway. But with most emerging markets competition authorities, the question comes down to whether truly the consumers in that singular country are harmed in any way or could be harmed in any way. Could there be any anti-competitive effects of this vertical arrangement? Whereas sometimes the effects are presumed, especially in the EU, because the free flow of the goods and services is in and of itself a separate goal that is being followed. Now, where do we see partly these kinds of differences? For example, in the Turkish example, we are seeing per a saga of Glaxo Wellcome and then Pfizer and then lastly Johnson & Johnson decisions, we are seeing that the Turkish Competition Authority is lenient to absolute bans or is more lenient toward absolute bans of export. And also even clauses that go into the territory of I'm going to track this barcode of this particular pharma product, and if I find this in outside Turkey destinations, then I'm going to reverse engineer how it got there, and if it is you that sent this out, then you're in trouble kind of approaches. And the logic behind it is that the product is abundant in Turkey, that all these restrictions mean that the product is not able to leave Turkey, which means more supply in Turkey, which means a better situation for the consumers in Turkey. So long story short, basically the Turkish Competition Authority's approach in these kinds of instances is that these absolute bans are leading to more product availability in the country, which in turn means that they're not able to come up with a theory of harm. They do understand that absolute bans of resale are considered bad in competition law, but for lack of any effects in the Turkish country, in the territory of the Republic of Turkey, they're not going to say anything about it, and it falls outside the scope. Then comes into gameplay a step further than that, which is a different type of writing of the same kind of clause, where the company then says to the reseller, you're not going to sell this product to outside of Turkey destinations, active or passive. You're just not going to sell this. This is already accepted by the Turkish Competition Authority as okay, because it defines the outside of country destinations are anything as anything that is outside of Turkey, and this leads to more availability of the product in Turkey. But the drafting says you're not going to sell these products that you're taking from me to outside of Turkey destinations, and you're not going to sell to counterparts within Turkey whom you know are selling to outside of Turkey destinations. Then the Turkish authority says, hey, hang on, now there is effect in Turkey because this particular trade was going to happen in Turkey between Turkish counterparts, and it's not happening because apparently that second recipient was going to sell it to outside of Turkey destinations. But then there is a whole debate about individual exemption, and the authority has proven that on this basis they are quite warm to giving individual exemptions as well, because they're still feeling that ultimately the upshot is that this is all discouraging exports from Turkey to outside of Turkey destinations. Now, this is an interesting debate because you could make a case that the effects are born in outside of Turkey jurisdictions. So let's assume that these products were going to go to Greece. Well, the territory of the EU is impacted. So while the Turkish authority is not going after this kind of a clause, it is not unthinkable that the Hellenic Competition Authority or even the European Commission, depending on whether these products are also going into interstate trade between member states, could take interest in this. But as far as the local competition authority is concerned, the main question to be asked is, doesn't this mean that my consumers end up with more products? Yes. Then why am I interfering? So that's one interesting bit. Another interesting thing is to observe that the Turkish Competition Authority and some of the other emerging market competition authorities have been quite keen on making sure that internet sales are not tampered with, and restrictions on sales through distributors' websites imposed by a supplier has always been seen as a restriction on passive sales, both in Turkey, but also in surrounding countries as well. In most emerging markets, I would also include the likes of Brazil and what have you. So the internet sales have been always very valuable because it keeps the market quite fluid. So purchases made through consumers, visits to dealers' websites, contacts with dealers, or requests to be auto-informed by dealers are considered as passive sales. There are very many examples of this. And I would say that the emerging market authorities have picked up the ball on the internet sales matter very quickly, and they have concentrated on this matter very quickly, because a lot of the sellers in these countries, especially in cosmetics markets, but also in some other markets, have wanted there to be some form of quote-unquote discipline in internet sales, and they were thinking that they were hit by these internet sales. Similarly, another topic that the emerging markets authorities were very quick to pick up on, and the Turkish authority is no exception to it, was the MFN clauses matter. The Turkish authority was actually one of the most draconian authorities in being quite heavy-handed on the MFN clause matters. You would be interested to know that as far as the Booking.com matter is concerned, the Turkish Competition Authority was the very first to impose an administrative monetary fine. And this was also for lack of a settlement mechanism in the country, which now exists. But back in the day, when Booking.com has approached the Turkish Competition Authority and said, well, we're going to migrate to a narrow MFN if you were to agree that this is going to solve all of your problems, the authority basically said, it does solve all of my problems, and I can't live with the broad MFN, but the narrow MFN is okay. But what are we going to do with the time period where you have used the broad MFN? For that, I will have to come up with an administrative monetary fine, and I'm unable to settle the case because we have no settlement infrastructure in our legislation. Now, there is a settlement infrastructure in the legislation, so query whether it would be a different outcome if the same thing was happening today. The Turkish authority was heavily influenced by some other authority. Influenced, I don't mean to say that they actively went in and manipulated the Turkish authority or anything like that. I'm saying, like it happens between different governmental agencies of different countries, there was information exchange between the Turkish authority and the other authorities, and especially the Bundeskartellamt's take on the Booking.com matter has been quite influential in how the Turkish authority has looked into this matter as well. So now there are quite many cases that have dealt with the MFN clauses, and any form of a broad MFN is not accepted in Turkey. There is also a drafting difference that I observe in emerging markets. I have seen clauses in the CIS of MFN. I have seen clauses in the Gulf region as well. Typically, the authorities are reacting to it when it is written in the form of, you are not going to give better terms to any of my competitors. Whereas if it is formulated as, you're going to match with me whatever better terms you might give in the future to my competitors, this sits better with the regional competition authorities in the Gulf region and in the CIS, and they feel that the first is formulating that there is an absolute cap, and the other one does not. My last point, and I'll wrap up in 2 minutes, is a very interesting new development in January 28th of this year, where the Turkish Competition Authority has openly taken a stance in a filing of Johnson & Johnson after reviewing an individual exemption application for more than a year. They basically, this is me saying it, but if you read the recent decision, this really does come across as the upshot. They said selective distribution cannot happen in pharmaceutical products, full stop. So this Johnson & Johnson decision is really a huge deal at the moment in Turkey, in the sense that they found that when the pharma producer is limiting its distribution to 9 warehouses that are selected according to an objective criteria list, the mere fact that there is an objective criteria list and the mere fact that this is actually carrying all the conditions of selective distribution does not mean that the pharma producer can engage in restriction of passive sales to warehouses outside of the system, because this system in and of itself is not bringing any new development or improvement. Consumers cannot benefit from this. And this is eliminating competition in a significant part of the market. And whenever they're engaging in these verdicts, they're basically relying on facts that are so intrinsic to pharma markets being pharma markets that you're left with the impression that no one can come up with a selective distribution that is narrowing down the scope of distribution of pharma products, because this is going to rub the Turkish Competition Authority in the wrong way. With that, I conclude my remarks.